I think that Kenosha County's positions have been set out relatively clearly in our moving papers, our petition, the brief that we filed with this court yesterday. And I believe that the evidence that we heard today supports our position. We're not disputing that it is difficult to place individuals convicted of 980 offenses. However, that doesn't mean that the right steps can't be followed, that factors shouldn't be considered. And here I believe we've got several concerns with regards to how this played out, the representations that were made to the court, and whether it or not, in fact, this is a suitable placement for Mr. McGee. We raised the issue of good cause to look outside of Kenosha County because the law changed March 1st of this year, Act 156. I think everyone in this room agrees that the purpose of that legislative change was to make it more difficult to send individuals out of county. It's hard, given sort of the short nature in which this hearing was set. I mean, I think we were in court on Wednesday. We're here today trying to essentially cross-examine DHS on all efforts that were made to find a placement. When in reality, Kenosha County has very little, has had little opportunity to investigate and find documents.
You were here last week.
Right.
I issued a stay.
Right.
I granted any extension you want for discovery.
Okay.
Don't feed this back to me.
Okay. No, that's, I agree.
Yes, I agree with that.
I'm saying, in Your Honor, and what I'll just leave it at is, I think Kenosha County, we find it difficult and disappointing to hear the testimony that there is no place in Racine County for Mr. McGee to be placed. Clearly, that's not what the purpose of the law was. It's not what was intended. And I think it's something that everyone should take another, essentially, look at. Aside from that, I think it's been Kenosha County's position that certain things should have been done once Kenosha County was chosen as its county of intended placement. And when you look at the supervised release plan that was submitted, I think it represented that certain things were done. For example, in the statement, it says that law enforcement was given an opportunity to share concerns or objections with regards to the placement of Mr. McGee. You heard testimony from Sheriff Beth and David Smith that didn't happen. At no time were they ever told that Mr. McGee was going to be placed in this residence. DHS testifies today through Dr. Kopesky that he welcomes input. It's difficult for the county of intended placement to give input when they didn't know that Mr. McGee was going to be placed here. Similarly, we presented testimony from Heather Beasy, who's the victim witness coordinator here, who testified that at no time was she consulted. She got an email after the fact. She got an email last week asking, whether or not she had any information. But DHS can't do that after the fact. It's an admission that the proper steps weren't followed, which is what our concern is to begin with here. Finally, I think the most important thing and what's been our position here is the court, at the end of the day, makes the determination as to whether or not the supervised release plan is appropriate in light of the treatment needs and the risks to the community. I think the witnesses that testified today from DHS conceded that the only way that the court can do that is if they have all of the information. DHS chose its words very carefully in how it represented to the court, that there was a residence that discussed, or a report that discussed occupants, that they considered the victims and his offense patterns. But what they failed to disclose was that there was a 1-year-old child living next door. And we understand now they're arguing it doesn't matter in light of the fact that he was never convicted, but if you look at the sexual bulletin notice, their own words describes his offense patterns. It describes his victims. To say that a 1-year-old resident doesn't fit is I don't want to say disingenuous. It's not consistent with how DHS has represented Mr. McGee, his offense patterns, what should be considered. Again, I think that it's something that the court should have been made aware of. We're asking, in light of all of the information, in light of the fact that there's serious question as to whether or not the proper procedures were followed, that the court rescind the placement and the approval of the supervised release plan and go back and look for a more appropriate residence for Mr.